So today we're going to be looking at the topic of devolution in the UK, and I am delighted to be joined by a champion of politics in the UK, Naomi Long, MLA. Naomi, thank you so much for joining us.
Well, thank you for the invitation. Happy to be here.
So Minister Long is the Minister of Justice in the Northern Ireland Executive, and she's a member of the Northern Ireland Assembly. So people who are members of the Assembly are called MLAs. She's also the only person in the UK who has represented constituents at every level of governance that is possible in the UK. She's been a local councillor, she's been the Lord Mayor of Belfast, she's been a member of the Northern Ireland Assembly, the devolved legislature for Northern Ireland. She's been a member of Parliament in Westminster, and until the UK left the EU on the 31st of January this year, an MEP in the European Parliament. Naomi, I'd like to ask you some questions, first of all, about the devolution settlement generally and how that works in terms of drafting legislation and creating laws, and then talk specifically about your role as the Northern Ireland Justice Minister.
Sure.
So we've just started our academic year, and the first module that we teach is about the structure of the UK legal system and constitutional law. Because of Brexit, we just felt that it was necessary this year to flesh out devolution in a lot more detail than we would have normally been used to before. And so it's one thing to explain the devolution settlement with abstract references to transferred or devolved powers and competences, but you literally live it because you're an MLA, you've been an MP. Can you just, how do you explain devolution to people, maybe even when you were in the European Parliament, who wouldn't necessarily know the centralised nature of UK governance?
Sure. Well, I suppose it's complicated in some by the fact that the devolution project in the UK never actually reached its completion. So it was always anticipated that they would devolve powers to Scotland, Wales, Northern Ireland, but that also there would be regional assemblies throughout England, so that if you like, the UK Parliament would deal with national issues, so things like national security would remain with the UK Parliament, but that other issues could be devolved to more local levels of government. So you would have things like health, education, local justice issues and so on that would be able to be devolved. That never happened, and so we have a slight anomaly in that the UK Parliament also governs for England and occasionally also a bit for Wales. And it becomes quite complicated, I guess, to see where the divisions between powers are. So that's an extra complication that we have that wasn't anticipated. In terms of Northern Ireland, Scotland and Wales, we also all have different levels of devolved powers and competencies. So Northern Ireland has quite significant powers, actually, in things like employment law. We have more devolved authority than any other of the legislatures. Whereas Scotland, for example, has much more developed tax varying powers than Northern Ireland or Wales. Wales is probably the one which is lightest touch. So the majority of Welsh policy, for example, when it comes to justice, is handled in the National Parliament in Westminster, and their Justice Minister would be more about how it's implemented locally rather than actually developing the law. So it varies from place to place, so that's a complication. And also, I suppose, there is a different means of government in each place. So Northern Ireland has a very specific arrangement which takes account of the kind of historic tensions in Northern Ireland, whereas, for example, Scotland has a much more traditional model of government, as does Wales, in terms of how its assembly actually operates.
So then, before we start talking about the relationship between those different legislatures and how the competences are divided up, can I just ask, do you have any theory about why England never got the devolved settlement that it was intended to have?
I think some of it was about the fear that it would create duplication of powers. Like some of it was down to the fact that the government changed before those processes had actually been gone through. And there was never the same appetite, I don't think, in England for devolution. Certainly not in the southeast of England where Parliament is located. There was never the same appetite for having devolution. So I think for that reason, it has been a bit of a hit and miss process. I mean, there are local assemblies in places like London, for example, and there's increasing interest in devolving some powers to, for example, we have now new mayors in places like the Mayor of Greater Manchester. So we have in Greater Manchester a mayor's office, which has more devolved power than would be the case in most mayoral offices. There's been some nod towards the need for devolution for the English region. I just don't think the appetite was there, whereas I think in Wales and Scotland and Northern Ireland, because of their distinct nature and distinct politics, there was a genuine desire to be self-governing at some level. And I think that was filled by the kind of devolution project, and that's why it went ahead of the situation in England. I think it's also fair to say that the composition of the Parliament, the UK Parliament, is such that essentially it is an English Parliament in all but name. You have 50 odd MPs from Scotland, you have 18 from Northern Ireland, you have another group from Wales. But generally speaking, the majority of the 650 members of Parliament are English. And therefore, perhaps people don't feel so disenfranchised in that sense, because they know when they elect their local MP, that MP will be part of a government party or part of the main opposition party. We don't have that luxury, and the same would be true in Scotland. So, for example, the majority of Scottish MPs at the moment are members of the Scottish National Party, and it doesn't feature in government, and it isn't the main opposition. In Northern Ireland, our own local parties, again, tend to be much smaller and therefore don't have the same amount of influence. And the same is true to a lesser degree in Wales. So I think for that reason, the demand and the appetite for local local government and devolution was much, much greater in the regions than it would have been necessarily in England.
So I couldn't help but notice that you talk about the desire for devolution in the past tense. Do you think that Brexit has had an effect, or is a consequence of, but also has had an effect on changing attitudes in England for more devolved powers to the regions?
Yeah, I mean, I think that there are a couple of things that have happened with Brexit. I think, first of all, there's a resurgent English nationalism, which wasn't a feature at the time when devolution took place. I think that's much more certainly much more vocal now, but I get the impression that that's also a bigger issue for the government to have to deal with. And there is a tendency, because the government is largely England based and so on, that can colour how it interacts with the other devolved assemblies. And so I think that there are challenges around that. I mean, Brexit was by and large an English and Welsh project, but mainly an English project. So I think that people voted for, certainly people in Wales mainly voted for Brexit out of frustration with the lack of investment in their local economy and so on, not out of anger about Europe. And I think the difficulty was that the real Brexit kind of purists who wanted to see us leave the European Union were really very much Anglo-centric. So Scotland was against leaving, Northern Ireland was against leaving, Wales was quite balanced, but definitely in favour. But England was where the referendum was won, essentially. And in some ways it's quite difficult, because it has created this divide in the UK where you have devolved assemblies. And in fact, in the case of Northern Ireland, a devolved assembly that is probably more affected by the impact of Brexit than anywhere else, because we have a land border with the Republic of Ireland, but we also have a sea border with the rest of the UK, and so we have to deal with all of those challenges, and yet it's something that we didn't anticipate we would ever have to do or want to do. So that's been quite a challenging period, I think, for devolution, because there's been a lot more pushback locally against, if you like, the prevailing direction of travel in Westminster.
This wasn't going to be a talk about Brexit, but I think it's kind of happened.
Yeah.
What's your view on the backstop and this stuff with the internal market bill violating in a very specific and limited way the withdrawal agreement, and what's going to happen at the end of this year for Northern Ireland?
Well, the truth at the moment is that we don't know. And I think that there's a lot of high stakes games being played out in public. I think that the government, I'm not convinced, are negotiating in a completely bona fide way in terms of their engagement with their European counterparts. I think what they're trying to do is kind of play this kind of high stakes poker game in the hope that they will get more out of this negotiation than they anticipate. I think it's misguided. I think it's very high risk, because actually what we need in Northern Ireland is certainty and clarity so that we can prepare for whatever happens in the 1st of January, because we have a lot of work to do, but we can't actually do that work because of the uncertainty. I think it also has ramifications in terms of community relations in Northern Ireland, which were completely ignored, just given that the border has been really the defining question in Irish politics now for the last 100 years. It's hard to believe that exit from the EU, that no one thought that might have implications for community relations and politics in Northern Ireland, but actually the degree to which people, again in England in particular, are detached from that reality, I think has become very clear through the Brexit process. In terms of how the government are handling it, I mean, I don't agree with their handling of it. I didn't vote for the withdrawal agreement when I was in the European Parliament. I believed we needed a withdrawal agreement. I believed that we needed a deal, but I believe that Theresa May actually negotiated the best possible deal with the backstop in place, which was a much preferable deal to the one which Boris Johnson cobbled together last year. And I don't believe that he really thought through the consequences of the protocol. The protocol itself has created a lot of tension because it creates internal borders within the UK, which are very sensitive issues for unionists in Northern Ireland, and also doesn't rule out the need for a land border either. And so we have this anomaly where now we seem to have more borders than ever before, at a time when actually the direction of travel had been up until now very positively towards borders mattering less and less. And that was actually good for our peace process, our stability, and for community relations. In terms of the internal markets bill, I mean, as Justice Minister, I think you'll appreciate that I don't think breaking the law in a limited and specific way is much of a defence if you're in court. And I don't think it should be much of a defence if you're in government either. Fundamentally, when you make deals at an international level and you write those into law, you should respect the law. And it sets a very bad example, I think, at national level for members of government to think it is acceptable to break the law and to openly state they intend to break the law. I think it's an act of provocation in terms of their engagement with the European Union, but it is also, I think, a way that will destroy the trust and respect and confidence that other countries will have in any deals that they would do with the UK. So I think effectively what it does is undermine your international standing, make it much harder for you to do not just your deal with the European Union, which is crucial, but also to cut all of the future deals that people have been dreaming of all this time. Brexit was all about us being able to make our own way, make our own deals. I've never been convinced of those arguments, but I'm absolutely convinced that we're not going to do that if we're not a trusted partner when it comes to making deals. And I think most of us would know that if somebody had cheated on another deal that just made with somebody else, we wouldn't be making personal deals with them. And the same is true when it comes to international law. So, I mean, I don't think it's acceptable. And I also think it sends out quite a damaging message in a part of the world here in Northern Ireland where adherence to the law is not an accepted thing for all communities at all times. And we're constantly challenging to try and create a culture of lawfulness in our society and to restore that after what was a very difficult period during our troubles here. And I think that for government, and particularly for the Secretary of State for Northern Ireland, to talk about breaking the law as though that's ever an acceptable solution to our problems, I think is setting a really poor example. And I think it was a very, very unfortunate thing that they've done. I also am not convinced, by the way, that the internal markets bill will work anyway. So apart from whether or not they were right or wrong to do it, I think it's a completely ineffective vehicle to try and achieve what they'd hope to achieve. Seems to me that they set out to achieve Brexit, which, you know, would give them all of the benefits of being in the EU, but none of the restraints. And unfortunately, as with any club, when you leave, your access is limited. You don't get to go back and use the facilities on your own terms. And I think there was just a completely unrealistic expectation. And I think it speaks to a form of actually quite difficult exceptionalism that the UK has exhibited within the European Union for a long time. They never saw themselves as one amongst equals. They always saw themselves as a place apart. And I think there's a real challenge now in terms of reality striking, because when we go out into the big wide world and try to do those deals, we're just a small nation now doing deals with what are large trading blocs all around the world.
So I want to ask you some questions about your role as the Minister of Justice and how that's going to affect cross-border investigations of crime. But before if you don't mind, something you just said makes me want to ask a different question, because you have experience as an MEP of how the EU machine works from the inside. So like, you know how, you know, that might affect the way we'll interact with the UK as a small country once they leave the EU. Like, how do you think that's going to be? Like, what, from your experience?
Well, I think it's going to be a massive cultural shift for the UK, because actually the UK has played a very leading role in the EU for many, many years. That's not how it's seen at home. I have to say that when you are in the UK, people think that we were bossed around by everyone else, and governments have played along with, I think, that very dangerous media narrative for a very long time. But in truth, when you speak to colleagues in the European Union, the UK was very highly respected in terms of the work that it actually did there, and the leadership that it was able to show around some core issues around democracy, personal freedoms and so on. And all of that was actually very much welcomed in the EU. So from that perspective, I think that it will be a major culture shift for the UK to be outside, because the UK is used to being able to substantially influence EU policy. It may not always get what it wants, but it will get a lot of what it wants. From now on, we will simply be reacting to EU policy. We will still be affected by it. It will still impact on our everyday lives, because that's what happens when you're nearest neighbours with someone. You don't suddenly, all of the effects of EU policy won't go away. And so I think that there's a lack of appreciation of just how much the balance will shift. So where people came to the UK seeking advice and guidance and support for things, that will no longer happen. And we will now be in a situation that other countries here outside the EU, but beside the EU, find themselves in. And most of them would say that they have had to invest a lot of money and a lot of energy and a lot of time building up relationships and that kind of soft power that you need to influence the EU. And I'm not sure that the UK has fully appreciated that all this money that we're going to get back from the EU, apparently, because we're no longer members, a lot of that is going to go straight back into a piece of work to start engaging again with the EU from a different place. And so I'm not sure that it's a good value for money exchange that we've got involved in, but I'm also not sure that we will have the same impact. I think the best place to be when decisions are being taken about your future is at the table. And so I think it's important that if we're going to have discussions about what happens next, that we're there, we're influencing, we're challenging, and our voice is being heard. I think being outside the room and passing notes under the door is not where anybody wants to be. And yet essentially that's where all of the other countries that surround the EU but aren't members end up being. And I think that will be a massive culture shift. I think also in terms of the EU, I mean, one of the things that really struck me being there, first of all, was, well, there were two things I would say. The first is that the EU isn't just a parliament. It is one of the biggest legislators in the world. So what you have coming out of EU today will end up being policy in places like America and Australia and other places in the future. So what it has is this massive legislation machine. and regulation machine. And it does that really, really well. But in order that others will interact with it, others then adopt those standards. So by being inside the EU, you're actually at the forefront of getting those standards shaped in the way that you really want them and that works for your economy. When you're outside, to some degree, you're adapting what they do anyway. So the idea that we'll suddenly be free of the fetters of the European Union is a bit naive, because in truth, international law and practice tends to follow what's driven by Brussels. That is the engine that drives the kind of international legal system and the kind of regulations and everything else. So we're still going to be, I think, very much part of that, whether we want to be or not, but just with reduced influence. The other thing that I think people misunderstood about the EU, and it comes back to the different kind of political chambers that we've sat in, I don't think people looking at the Westminster Parliament really understand coalitions and that kind of collaborative policy making. So I sit in an executive that has 5 different parties in it on a mandated basis based on their votes. We're not there out of choice. We don't choose to go into government together. We basically make the numbers, and that's how we're appointed to government. And it's a very difficult and at times quite testing environment to be in. But you learn from that how to negotiate your way through with people with whom you have very little political agreement, but how you can put your interests to one side politically and deal with practical issues in a constructive way. And in the EU, they're very skilled at doing that, about building coalitions, about negotiating in advance, about actually working between the party groups. There's a lot of tick-tacking goes on behind the scenes in order that when things come to the Parliament, they get approval. And people see that in the UK as anti-democratic, because the system that they're used to is a very polarised, bipartisan approach, where it's all about confrontation and the winner takes all. And the European Parliament is not about winner takes all politics. It's about consensus and maximising consensus. And so I think part of the reason that people in the UK saw the European Parliament and structures as anti-democratic is partly because they couldn't relate to them, because the very bipartisan and polarised style of politics in the UK is actually quite unique. Only really here and in America you get that kind of polarity. In most places, coalition is the norm, certainly in most places in Europe. And I think perhaps people in Northern Ireland and in Scotland indeed better understood the politics of Europe because it was something they were more accustomed to, because in the devolved administrations, actually in the majority of mandates, it has been coalition governments in each of those devolved administrations. So I think that there's a challenge there about just the lack of ability to relate to the way European politics is done, because it's not how it's done in Westminster. And I think at times that maybe blinded people to the fact that it isn't undemocratic, it's just different, but equally as democratic, and I would argue actually much more stable and inclusive.
So do you think it was a mistake that the Westminster first past the post model didn't accept proportional representation, which would have brought in the idea of coalitions into UK governance? Do you think that's where we're going?
Yeah, I mean, very much so. I think PR was a missed opportunity. I think we should have proportional representation. I think that the UK elections are not, I mean, the Parliament is not reflective of the voter percentages across the country. Small parties are underrepresented, larger parties are overrepresented. And we also get these massive swings in elections where you go from being led by a Conservative government to a Labour government to a Conservative government, and the whole machinery of government has to do a U-turn on major policy issues and spend a lot of time, frankly, undoing what the last government has done. When you have coalition governments, what you tend to get is incremental change. And so it's not that it inhibits change, it doesn't, but it tends to be incremental change, and you get an awful lot less kind of nugatory work from government that then gets overturned by the next government who comes in immediately. And I think that kind of swings and that kind of pendulum swing that we get in UK politics isn't actually great in terms of stability and in terms of consistency of approach. And from my point of view, I think coalitions are not a bad thing. Inherently, they take a lot more work than single party government. And it's great. I mean, I would love to be part of a single party, alliance party government and storm it. It would be fantastic. You would get so much done so quickly. But at the end of the day, it kind of defeats the purpose, because you're only ever looking to one section of the electorate and you're only really serving that section. Whereas I think a coalition forces you to actually test your views and your ideas against how other people from different political views will see that, and actually moderates the choices that you make. And I think that can be quite a healthy thing.
And do you have any predictions for the next 5 years, 10 years in terms of constitutional changes within the UK? Like, if we exclude the possibility of major change like Scottish secession from the UK or a referendum on reunification of Ireland, like ignoring the big events, like just incremental change, as you say it, like do you see any changes or a move towards a federated UK or something like that?
I think one of the stark things that has happened as a result of Brexit is that you can't ignore those potentially large changes. I think that things like Scottish independence, things like reunification of Ireland, all of those things are back on the agenda to some degree as a result of Brexit, and the dissatisfaction with the level of disconnect between the different nation states within the UK and the UK government. I think that, we've even seen a growth in Welsh nationalism, which, had kind of withered on the vine for a very long time. And yet now we're seeing increasingly a rise in the support for Welsh nationalism and more devolution or independence. So I think those have been seen even 5-6 years ago as unlikely. I think now they're very much back on the agenda in terms of people talking about them. Setting those aside, I think that the trajectory would be towards more devolution. I think that that's what people will want, is more of what we already have. I think the government, though, the current government, isn't necessarily a pro-devolution government, and therefore there will be a lot of resistance and a lot of kind of push and pull to get anywhere. I think if we have a change of government, of course, then everything is up for grabs and could change dramatically. But I think with the current government, they will resist further devolution, and we've seen on occasion where through the European exit process, they've actually tried to centralise more powers back into Westminster again that had previously been devolved competencies, but obviously had gone to Europe. And so I think there are real challenges for the devolved administrations in terms of challenging to get those powers back when they're back in the UK, that they come back to the devolved administrations. So it's hard to know, given the way politics is operating in 2020, I wouldn't want to predict 5 minutes ahead, let alone 5 years. But I think that there will be, and I think it's almost an inexorable demand for more localized power. I think it's something that people, whilst they get frustrated with devolution at times, particularly in Northern Ireland, because it is quite a clunky system, I think ultimately people would rather be governed by people who have the same lived experience, and they don't feel that is the case when you're dealing with Westminster.
And what are the channels of communication between the devolved legislatures and executives and Westminster, especially now with Brexit and the repatriation of EU powers back to the UK?
Well, there are a number of formal mechanisms that we have in terms of the engagement that we have, but we also have a lot of informal day-to-day working. So in my own department, for example, works very closely at officials level with the Ministry of Justice and the Home Office in Westminster to make sure that we join all of the dots in terms of justice and security and all of those different pieces. So there's a lot of good ongoing work that happens there. We also, as an additional layer, we have to make sure that we coordinate with the South of Ireland as well. So we have the North-South Ministerial Conference, we have the NSMC meetings that happen on thematic basis. So that gives us an opportunity to meet specifically on issues such as agriculture, environment, transport. So areas of genuine cross-border practical interest where we need to coordinate our activities and look at joint projects that will allow us to better serve the people we have on the island. So there's a lot of, I think, good work that goes on cross-jurisdictional, but also then across with Westminster, and good contact. And obviously, you know, my own party has an MP in Westminster, so we're close to what's happening there. And we also then have a minister in government in Northern Ireland, which again gives us the opportunity to be across the detail of what's happening here. But generally, the cooperation at that level, at the practical level, is quite good. I think where it falls down slightly is around the kind of political narratives that are chosen by government and how things are expressed, which often I think lack a sensitivity to the Northern Ireland situation. And there isn't always a full recognition of how challenging Brexit is for us, given our intricate links across the border and that people live cross-border lives. You know, people didn't see any issue with needing a green card to travel abroad in your own car. Because for people in England, it's a kind of holiday thing of going to the south of France once a year. For people in Uri, it's a thing you do maybe on a daily or at least a weekly basis, because you're going to pick your kids up from school or visit your grandmother or whatever it might be. And I don't think there was the same recognition of how our lives are so interlinked across the border. And I think that has been quite challenging to explain to an island nation that doesn't really understand what it's like to have hard land borders to deal with. And to be fair, I think that the softening of the border has been hugely beneficial in terms of business, in terms of society, in terms of politics, actually, and community relations. And so I suppose our fear was what impact any additional infrastructure around the border might have, both from a security point of view, but just also at a very practical level in terms of impeding business, impeding travel, impeding people's social contact and their mobility. And those are things that I think we're right to be concerned about and remain concerned about until we see a final package that will protect us and we know for sure how that's going to work.
I'll just pick up on one of those areas of cooperation that I assume would be relevant for the Justice Ministry, and that's cross-border cooperation in policing and investigation matters. So like once the transition period ends, I assume with or without the backstop, Northern Ireland is going to leave the area of freedom, security and justice, and cross-border cooperation in policing matters is going to have to be on some completely different legal footing. Like, how are you preparing for that?
Well, I think there are a number of things. There are two negotiations going on at the minute. The one that gets all the attention is the negotiation about the final trade deal that will be done. But there's actually the future security partnership negotiations, which are ongoing too. One of my concerns, I suppose, is that whilst the future security partnership seems to be a much more productive conversation and seems to be making much more headway, we're still coupled to the trade talks. So unless we get a trade deal, a comprehensive trade deal, we won't get a future security partnership negotiated. There are a couple of things that I think will be challenging. First of all, there are some backstop arrangements. So we would be going back though to 1950s, kind of different treaties that were made in the 1950s. And it's hard to see how those are going to be adequate in terms of policing 2020 and beyond. So, you know, none of them are going to be as good as the current relationships that we have and enjoy and the current levels of cooperation. But they are there. So things like the Lugano Convention and others, well, we can fall back on some of those in terms of dealing with issues of justice and security, but they're not ideal. The other issue for us, which is crucial, is about live investigation. And we know that on a cross-border basis, when we're dealing with things like organised crime, with terrorism, and so on, it's really important that the Garda Síochána from the Republic of Ireland and the Police Service of Northern Ireland are able to work in live time with each other on those investigations. That means sharing data, and that means we needed a data adequacy agreement. And at the moment, that hasn't yet been agreed. So If we don't have that, that will mean that we can't do that live data sharing. We wouldn't then have access to some of the key data tools that we have previously not just had access to, but had input to. So, for example, we know we probably will be excluded from the Schengen information system, which is fair enough because we're not part of Schengen and have never been, and we're not going to get that level of access. But there are other databases like PRUM and others that we do need access to. It's absolutely critical if we're going to challenge organised crime right across Europe and beyond. We need to be able to still work with Europol and Interpol. We still need to be able to do cross-border extradition work. We still need a lot of the other agreements that are there to be replicated. So there's a lot of work happening already in terms of trying to find either alternative ways that we can do the same thing, or to get the data adequacy in place so that we have access to those tools. In terms of other issues which people often forget about, but things like, for example, private international law, we have already passed a local consent motion to allow Westminster to go ahead with legislation to, if you like, bring across all of the EU standards for private international law. That's really important in terms of allowing businesses to be able to challenge where there are issues around that, but also to allow family courts decisions to be recognised across Europe, and also their court decisions to be recognised here. So, for example, when people go abroad after having a decision made about child maintenance, being able to pursue that person to continue to make their payments, that will all fall apart if we don't have those standards put in place. So both in terms of civil law and also criminal law, there are massive gaps which we are working hard to fill. But I think that whatever we come up with will be suboptimal when you compare it to the current integration that we have within the European Union. And I think that, again, that's something that wasn't fully considered. People looked at this purely as an economic project. Some looked at it purely as a sovereignty project. But what they didn't really understand was just how embedded and how interwoven all of our systems are. And to try and unpick those, you will lose some of the fluidity and agility that we now enjoy. We had particular issues in Northern Ireland for many years in the 70s and 80s around extradition. And it became a very politically fraught and difficult issue. And we would not, under any circumstances, want to be back in that space again. And the saving grace for us and for the Irish government was the European arrest warrant, which actually took it away from that kind of very highly politicized environment and made it a practical exchange issue. And that has been a fantastic opportunity for us to be able to pursue criminals on a cross-border basis. So all of those things we need to make sure in our bilateral work with the Republic of Ireland that we can replicate that work, those working arrangements. That work is underway, but the big challenge that we have is that the only basis we have on which to make bilateral agreements is through the protocol. So if the government undermines the protocol, they are actually not just undermining the opportunity to get a deal, but they are undermining the fallback position of being able to negotiate bilateral agreements if we fail to get a deal. And that's, I suppose, what made me so concerned about the fact that they had decided not to take the protocol seriously and to introduce the Internal Markets Bill, because it wasn't just jeopardizing a comprehensive deal, it was also jeopardizing our protections if such a deal wasn't forthcoming.
Do I understand correctly? Because I didn't really understand that completely. If just take the European arrest warrant as one example. So as I understand it, the European Court of Justice has already said that for as long as the UK is in the transition period, then European arrest warrants can be executed to the UK. But at the end of this year, is under the protocol, is Northern Ireland able to negotiate with the EU for its own version of the European arrest warrant that doesn't include the rest of the UK?
We'll have to come up, we can negotiate particularly with each with each individual nation state. So essentially, that's how it would be done. Now, if we can get a comprehensive deal under the Future Security Partnership, that would be a universal approach across all of the states. If that fails, then we would have to negotiate with each individual European country. And the protocol is the basis on which we would be able to have those discussions. So that's one of the reasons why it's so important that we don't undermine the withdrawal agreement and protocol, because it provides us with the opportunity, if we have to go back. But you can imagine how clunky it will be if we have to negotiate 26, 27 different extradition arrangements with each European state, rather than simply having a one-size-fits-all approach. The European arrest warrant, I mean, I have to say, it was an absolute godsend for us, because it was so easy before. Criminals being pursued by the police would stroll across the border and wave back because they knew that they were free. And we could not go back to that kind of situation, because it would completely undermine public safety and public confidence. So it's really important, and I know that the Irish government are very committed to working with us to make sure that doesn't happen again. But it's frustrating when you have a really good solution and it's taken away, and you're then trying to scrabble around to find a way to replicate it. What we had was perfect and fitted us well, and it's just unfortunate that we're in this situation.
I imagine then that one of the kind of good outcomes from that process would be that fundamental rights protection will be maintained in Northern Ireland, even if a future Conservative government makes moves to repeal the Human Rights Act. Because that would be a big factor in, the automatic recognition of a European arrest warrant.
Yeah, and I mean, for us, it's also crucial because it's a big part of what's expected from the Good Friday Agreement, that our rights are enshrined in that agreement, and that we are in a position where those are protected. I believe fundamentally that the conflation of the European Union with the European Charter of Human Rights is absolutely flawed. And I think that the UK government's wish to try and wriggle out of those obligations, which in fact the UK government was instrumental in drafting for Europe, I think is utterly flawed. I do wonder about a country that feels that in order to be its best self, it needs to reduce people's access to human rights. It doesn't suggest to me a very aspirational government or a very aspirational country. I think we should seek to have the best possible outcomes when it comes to people's human rights, the best possible protections. You seek to lead in these areas, not to be dragged along. And I'm very concerned about that. I think in some cases that, again, a bit like the European Union, the kind of Charter of Human Rights was used as an excuse when government ministers failed. So, I mean, I remember being in Westminster at the time when there was quite a furore about the deportation of a prisoner to their own home country, and they wanted to be deported and repatriated. And Theresa May made a really foolish statement in saying that she wasn't allowed to do it because they had a cat. And it went crazy in the papers, and the European Union was mad and so on. And of course that wasn't true, because I was so annoyed at what she'd said that I got my staffer, I was then in Westminster, and I got her to go to the research services in Westminster. And what had actually happened was that the UK had failed to carry out due process, because part of the due process that needed to be done was to check whether somebody had established a family life in the UK. And so the reference to the cat was not about the cat, but the fact that this person was married, was living as a family, and they were evidencing the fact that this was not a fake marriage, as so many people were trying to allege just for convenience, that this was a real family that were living. And they mentioned that they even had pets and so on. And, so the cat only really became an issue as part of the evidence that this person had a family life in the UK and therefore a right to remain in the UK, even though they were going to be in prison. And to dismiss it as though, well, because they had a cat, they couldn't be deported, that just was not the case. There was a wider family context that needed to be considered. But I think that it was an easy way of wriggling out of the actual judgment, which was that the UK hadn't followed due process. So it was that kind of dead cat bounce where you throw the most ridiculous part of a judgment out into the public domain. That gets all of the attention, and the nuts and bolts, the really dull but important stuff, gets completely ignored. And I think that that's a technique that a lot of politicians have used over a very long period of time to try to discredit the European Union. But what they have done is in fact discredit the whole concept of human rights and the need for a Charter of Human Rights and human rights protections. And I think that that is really, really foolish. But I think it's also very malign because it actually creates a culture in society where people think that human rights are some kind of a swindle rather than actually recognizing them for what they are, as fundamental protections that each of us enjoy. And I always say, when people are critical of other people exercising their human rights, be careful what you wish for, because your own human rights are only as safe as the human rights of others who are exercising them in a way you don't like. So if you're not happy with how others exercise their human rights, and you try to curtail that, it will bite you back, because your rights will be next. So I think we need to have a more informed and a more mature conversation when it comes to human rights than we're currently having in the UK.
So just following on from that, like, I can kind of imagine what your answer to this question is going to be. But as a UK Justice Minister, what's your view on the Home Office Secretary of State referring to immigration lawyers as lefty lawyers, and the Prime Minister kind of following on with that and not saying that that was the wrong thing to do?
Well, look, at the end of the day, I think that there has been a deliberate attempt during the Brexit process, and particularly around some of the very toxic immigration discussions that have been had in the UK, to try to demonise those in the legal profession who are standing up and defending people's rights. I mean, the fundamentals of the justice system require that everyone is innocent until proven guilty, that everyone has the right to a defence, and that if we start to chip away at that, if we start to suggest that someone coming to the UK has no right to defend their claim for asylum or for refugee status, if we start to erode those basic human rights, then I think we're on a very slippery slope. And I think that the UK's kind of policy of a hostile environment has been absolutely chilling. I think its impact on vulnerable people, in particular, those, for example, we've just finished a week of focus on people who have been human trafficked, and who are subject to modern day slavery. People who are afraid now to come forward because of the government's own hostile environment policy. So unless people feel that they are secure and will be cared for and will be treated with respect when they come forward, if their fear is that they will be repatriated and then trafficked again, that's not something that they're going to do. These are incredibly vulnerable people. And I think demonizing people is not the job of government. It's government's job to protect the vulnerable. It's government's job, if you like, to justify and educate the public about these things, not to play to people's worst instincts, and certainly not to scapegoat sections of society. When it comes to the judiciary, who have also taken a hammering, so we've had legal advisors and lawyers have been criticised by the government. The judiciary get criticised by the government. At the end of the day, as Justice Minister, I see my job as to defend the independence of our judiciary. I don't interfere. I don't argue with their judgments. I don't criticise. I'm there to provide a policy framework within which they work. But they are the judges. They are the ones who are qualified. They have to make those decisions and stand over them. And we shouldn't be criticising them publicly and undermining their position. I think that is really dangerous territory to get into. And I think judges, they don't always get it right. But I would much rather that they got it wrong independently than that they were having to deal with political interference on an ongoing basis. I look across to the States, and it really disturbs me the degree of political interference that there is in the justice system. I think the justice system works best when there is minimal political interference. By all means, as politicians, we should shape policy. But I think that the ultimate operational decisions when it comes to justice have to be with those people who have the skills and the experience and the independence to do their job without fear or favour. And I'm not sure you can really do that if you know that you're going to be subject to a re-election test every few years, or if you're worried that you might be replaced by somebody whose politics suits more the colour of the government of the day. And I think that all of the kind of language that's being used around the judiciary and around defence lawyers and so on, and around immigration, has been absolutely toxic in terms of fueling racism and xenophobia in the UK. And I warned about this 5 years ago when I was in Parliament, and I am more and more convinced that it was a lot of the driver for what happened with Brexit, and that it is a lot of the driver for some of the rather mean-spirited, frankly, public policy that we see being made in government today.
And do you think that the current UK government's review of judicial review is partly fueled by that's gone on before, as well as the Miller judgments in the Supreme Court, which obviously weren't in the government's favour?
Yeah, I think that is the case. And I mean, at the end of the day, the judiciary shouldn't have to agree with the government. The judiciary is there to uphold the law. And if the government doesn't like the law, they're well placed to change it. But what they can't do is just break it. And unfortunately, what we have seen is a government who seems to think it's okay to break the law rather than change the law. And I don't think that that's acceptable. You need a mandate to change the law. You can do that. I mean, I'm changing the law in Northern Ireland. I've 4 or 5 bills in preparation at the minute that will change the law. But they're things on which I have consulted. They are things that I have a mandate to do. And that when they're finally put in place, I'll respect them just as I would respect the law as it is at the minute. And it's up to the judiciary and the courts and so on then to uphold that law. The government at the minute seems to think that if you don't like the judgment of the court, that the court should go, not the government. And I just don't think that that's acceptable. I think we've got to maintain the independence of the judiciary, and that includes them being able to hold government to account when government fails and when government breaks the law. And even those people who are sympathetic to government, I think, ought to think twice about trying to unpick that independence, because that is our protection when government comes after us as the individual. That we know that we have the same recourse to the courts, we have the same ability to go to the law and to seek its protection as the government. And it's our only protection. So I think it's hugely important that we don't undermine it.
That's a really interesting point, and I'd like you to talk about it in one particular aspect, because a lot of our students come from countries where there are so-called rule of law crises, where there are perceived attacks on the judiciary by the governments. And I wonder what your perception is on like the idea is that the judiciary are an elite, and that's how they're perceived, and that's used as a means for the government to continue with certain policies that might not have otherwise been legal, but they can because the judiciary is no longer perceived as independent. Why do you think it's important for the judiciary to be independent?
Well, first of all, I think the judiciary have to be independent because they shouldn't be influenced by politics. They shouldn't be influenced. Well, because I think once you bring the judiciary inside the political system, then they are subject to the same whims and variables as politicians will be. So they will be looking over their shoulder at the next election. They will be looking over their shoulder at the next appointments process, and they will always be then tinged with the risk of populism. And unfortunately, good decisions aren't always popular. And I think when it comes to making decisions in terms of the judiciary, there is a balance to be struck. There has to be confidence in the public that the law is being upheld and that it's being upheld well. I think that is important, and that's where policy comes in. So when for example, we have sentencing guidelines. I've just gone out and had a review of our sentencing structures in Northern Ireland, and it's right that we should look at that. And understandably, most of the public will come back and say, well, yes, some sentences seem to be a bit lenient, but when we actually drill down into that, the majority of people in Northern Ireland still favour rehabilitation over punishment. They still want to see sentences that are not unduly long. They recognise that longer sentences don't necessarily lead to less recidivism in terms of criminal behaviour, and they recognise that good support for mental health, drug addiction and other things would actually be much more effective than simply incarceration. So when you talk to people sensibly about these things, they recognise all of that. But the emotion that will infect individual cases and decisions will obviously sway people's judgment. And it's really important that judges are free to be impartial and consistent in a way that doesn't require them to be well liked and popular. Because if they're seeking to be well liked and popular, then what you will get is the kind of very long kind of sentences that you see in parts of the States, which we know don't make the place safer. You know, it's a bit the argument around the death penalty. I keep saying to people, I mean, countries that have the death penalty don't feel to me like safe places. A lot of countries that don't have it do. So there's something that, although it might seem a deterrent in your head, it sounds reasonable. Most people don't commit murder thinking, now what will happen to me if I'm caught? For most people, it's a reflexive thing. It's something that happens. Most people who are convicted of murder in the UK, it isn't a planned event. It's actually a reaction to something that has happened. It's a moment of kind of a bad reaction to something that's happened around them. They're not thinking about what impact the sentence might have on their actions, because they're not planning a crime. They are reacting to circumstances in a very inappropriate way. Independence to do that, but they also have the independence to be able to challenge politicians who will often be populist when it comes to policies proportionate, where they feel that they can challenge that back. And I think that checks and balances have to be maintained in terms of the judiciary and the role that they play. I think that they can become detached. So, I mean, I'm not saying that the judiciary are perfect. I would like to see more women in the judiciary. I would like to see younger people on the bench, because I think that at the minute what we have, generally speaking, are older men who have a lifetime of experience, yes, but not the lived experience of the people who are appearing in front of them for sentencing, or the victims of the crimes that are coming to the courts. So I think that there is a danger in the judiciary that it looks out of touch or disconnected, and that is then exploited by politicians to undermine it. However, I have also met with many retired judges, and they are people of immense insight. They have huge repository of knowledge of the law, of understanding of cases and precedent. And obviously our legal system is based on both, on case law as well as legislation. And these are people with massive experience. And they are also people who are willing to challenge prejudice. So I'll give you a tangible example. One of our retired judges at the minute, John Gillen. So John Gillen has just undertaken a review of serious sexual offences and how they're handled in the court system. And a more passionate advocate for women, for women's protections, for taking crimes like rape and sexual assault seriously, for looking at how you protect vulnerable witnesses, how you ensure that women are not demeaned by cross-examination, and all of those things. You would not find more forward thinking than many younger people. So I think there is a tendency to assume that because someone is older, more mature, a man, whatever it might be, that they're incapable of empathy, understanding, relating to people's circumstances. And that's not the case. And so I think there is an argument for saying that the judiciary needs to be more diverse and we need to work towards that. But throw the baby out with the bathwater is not the way to do it, because we need the experience, expertise, and skills that the judiciary have, and we shouldn't dismiss it. And I always say to people that sometimes, and as a politician I've done it, I've written to the Lord Chief Justice and said, this case, the sentencing, I don't understand it, seems very lenient. I would be grateful for an explanation of how it was arrived at. And to be fair, the judiciary will write back and say, this is why. And I always am conscious that there are reasons for the judgments. They're reasoned decisions. And I think the information they have, and I think broadly they do a good job. So they're not perfect. They should be open to challenge. They need to be willing to train and to keep up with modern standards and all of those things. But I think that the attack on the judiciary itself is more worrying than the judiciary, because I think that the politicians who want to undermine the judiciary are not trying to stop elites being in control. They are elites who are already in control. What they want is more power. And I think people need to be very cautious about assuming that by undermining the judiciary, you're suddenly going to get a more egalitarian setup in the world. You're not, because politicians are as likely to be elites as anybody else.
So I think I only have time for maybe one or two more questions, like a couple more minutes. Have you got a couple more minutes?
Sure.
So I just wanted you, because you were talking about the reforms. And like the Crown Prosecution Service in England and Wales released its statistics on criminal prosecutions the other day. And in their statistics, they showed that maybe because of the pandemic, there is significantly less reporting of domestic violence and rape allegations by about 20% this year, and about 20% fewer charges are brought by the CPS, and prosecutions in domestic violence and rape cases are 50% down on last year. That's pretty extreme. Is that the same trend that's happening in Northern Ireland as well?
What we have seen is more reporting to helplines, so many more people phoning up and asking for help, and a lot of those people will not be victims of domestic violence or abuse themselves, but they will be people who are worried about family members or neighbours or friends who maybe they feel are exposed to domestic violence or abuse and they want to engage with. In our context here in Northern Ireland, there hasn't been such a dramatic change, but there is certainly an issue in terms of people being less likely to formally report to the police, and then being less able to detect those crimes during the pandemic. But we took specific action in the Department of Justice, in that first of all, we're legislating at the moment for a new domestic abuse offence, which takes in coercive control as well as physical violence. Okay. And one of the things we tried to do in that context was to actually highlight domestic abuse as an issue during the pandemic, encouraging people to speak up and speak out, encouraging people to approach support networks, charities. We also worked on things like free transport on public transport if people were leaving an abusive relationship. And we also then looked at some of the work that we're doing, for example, with hairdressers and pharmacies and other places where people would have the opportunity to be able to report an incident without their partner necessarily knowing. And we did a lot of social media and media campaigns to try and raise awareness of the helplines and so on. So we saw an increase actually in the reporting to those different helplines during that time, I think largely encouraged by a raised awareness in the community of the risks.
Okay. So I just want to ask one more very general question, and it's coming back to something you said earlier about the European Union being a legislature for the world, basically. So legislation can be adopted in the EU, but it's going to be implemented in other non-EU countries as well. So like, you were one of the last MEPs that came from a common law jurisdiction. So the majority of MEPs that are going to now sit in the European Parliament are from civil law countries, which have very different structures. So apart from Ireland, there's nobody else really, like maybe Malta and Cyprus will get it. So do you imagine that that's going to affect the ability of a post-EU UK to implement rules? Like, do you think that the law will change the structure in the EU, or has the influence of the common law already set into the way EU laws are adopted, do you think?
I think possibly things will change over time, but I think that will take a longer time. I think, to be fair, in the EU, that they generally set direction, and it's for individual nation states then to embed that into their own legal system. And so there's a degree of flexibility in terms of how things are interpreted within their own legal system. I think it's one of the reasons why some countries were quite reluctant about the UK leaving, because we had always been the kind of case that argued very strongly that you set the policy direction at EU level, you agree and introduce it into law in a way that was fit for purpose in their own jurisdiction. And I think to some degree there were more than just the differences between us having common law and others having different systems.
Okay.
I think there was also an appreciation of the importance of having local ownership of the law. And I think that that is something that I know that some of the smaller countries in the EU were quite concerned they might lose some of that autonomy because the UK wasn't there arguing for it very strongly. But I think that that change will be slow. I don't think it's something that we'll see overnight. And I think that a lot of the smaller nations in particular will want to resist it, because I think ultimately we all know that the law needs to be responsive to the citizens. They need to feel connected to it. And part of that is about shaping it for the culture and conditions in which the law is being made. And you can't really do that at the very highest level in the EU. You've got to devolve that down into individual nation states.
Okay, so thank you very, very much for giving us your time today
No
and
problem
sharing
at all.
your knowledge and your experience.
Thank you.